Good morning, house guests. Come on in, have a seat. I have some for you. I know I'm starting off a little bit early, but let me just give you a little bit of an intro. Yesterday, our first episode covered the Wayfair mission. We looked at Todd Black as far as the 17-point agreement. Um, and then in this episode, we're going to take a look at the lead up to the 7-point agreement. And then I'm going to ask really why wasn't Ryan Reynolds part of the 17-point agreement? And there's some questions about the metadata. Also, does Jamey Heath have a reverse Uno up his sleeve by way of Johnny Depp? So I will play a little bit of the Depp versus Heard trial and that verdict and what they were guilty of as far as defamation. It is very interesting, and I think it's going to hurt Lively and the New York Times. In my opinion, it's not very good for on their end. And then tomorrow we'll take a look a little bit more at Sony's possible reasoning for sealing, and then kind of how, in my opinion, Blake Lively and Ryan Reynolds totally screwed over Sony in a different way. And let me see if I missed anything. Okay, so let me play this Johnny Depp and Amber Heard trial verdict, and let me know what your thoughts are in the chat. This is going to probably be like 5 or 6 minutes or so.
Civil case number CL 2019-2911. Mr. Depp's claim against Ms. Heard. 1. As to the statement appearing in the online op-ed entitled, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change. In the Washington Post online edition. Quote, I spoke up against sexual violence and faced our culture's wrath. That has to change, end quote. Do you find that Mr. Depp has proven all the elements of defamation? Answer, yes. Has Mr. Depp proven by a greater weight of the evidence that, question, the statement was made or published by Ms. Heard? Answer, yes. Question, the statement was about Mr. Depp? Answer, yes. Question, the statement was false? Answer, yes. Question, the statement has a defamatory implication about Mr. Depp? Answer, yes. Question, the defamatory implication was designed and intended by Ms. Heard? Answer, yes. Question, due to circumstances surrounding the publication of the statement, it conveyed a defamatory implication to someone who saw it other than Mr. Depp? Answer, yes. Do you find that Mr. Depp has proven by clear and convincing evidence that Ms. Heard acted with actual malice? Answer, yes. 2. As to the statement appearing in the op-ed entitled, A Transformative Moment for Women in the Washington Post print edition and the online op-ed, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change, in the Washington Post online edition. Quote, then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out, end quote. Do you find that Mr. Depp has proven all the elements of defamation? Answer, yes. Has Mr. Depp proven by a greater weight of the evidence That question, the statement was made or published by Ms. Heard. Answer, yes. Question, the statement was about Mr. Depp. Answer, yes. Question, the statement was false. Answer, yes. Question, the statement has a defamatory implication about Mr. Depp.
Oh, sorry, that was an ad. Hang on. All right, I'm going back to it.
Question, the defamatory implication was designed and intended by Ms. Heard. Answer, yes. Question, due to circumstances surrounding the publication of the statement, it conveyed a defamatory implication to someone who saw it other than Mr. Depp. Answer, yes. Do you find that Mr. Depp has proven by clear and convincing evidence that Ms. Heard acted with actual malice? Answer, yes. 3. As to the statement appearing in the op-ed entitled "A Transformative Moment for Women" in the Washington Post print edition and the online op-ed, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change. In the Washington Post online edition. Quote, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. End quote. Do you find that Mr. Depp has proven all the elements of defamation? Answer, yes. Has Mr. Depp proven by a greater weight of the evidence that question, the statement was made or published by Ms. Heard? Answer, yes. Question, the statement was about Mr. Depp? Yes. Question, the statement was false? Answer, yes. Question, the statement has a defamatory implication about Mr. Depp? Answer, yes. Question, the defamatory implication was designed and intended by Ms. Heard? Answer, yes. Question, due to circumstances surrounding the publication of this statement, it conveyed a defamatory implication to someone who saw it other than Mr. Depp? Answer, yes. Do you find that Mr. Depp has proven by clear and convincing evidence that Ms. Heard acted with actual malice? Answer, yes. As against Amber Heard, we, the jury, award compensatory damages in the amount of $10 million. As against Amber Heard, we, the jury, award punitive damages in the amount of $5 million. In civil case number CL 2019-2911, Ms. Heard's claim against Mr. Depp. 1. As to this statement appearing in the April 8, 2020 online edition of the Daily Mail, quote, Amber Heard and her friends in the media use fake sexual violence allegations as both a sword and shield, depending on their needs. They have selected some of her sexual violence hoax facts as the sword, inflicting them on the public and Mr. Depp. Do you find that Ms. Heard has proven all the elements of defamation? Answer, no. 2. As to this statement appearing in the April 27, 2020 online edition of the Daily Mail, quote, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt did not do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911, end quote. Do you find that Ms. Heard has proven all the elements of defamation? Answer, yes. Has Ms. Heard proven by a greater weight of the evidence that question, Mr. Waldman, while acting as an agent for Mr. Depp, made or published the statement Answer, yes. Question, the statement was about Ms. Heard. Answer, yes. Question, the statement was seen by someone other than Ms. Heard. Answer, yes. Question, the statement was false. Answer, yes. Do you find that Ms. Heard...
Okay, house guests, did you hear that? So, you know how Blake Lively is harping on Brian Friedman and his statements about some of her claims being false. And she is going to the court and saying, this is defamation, blah, 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 blah. They're doing it in, court reporting, whatever, right? So now that I played that, I think Jamey Heath has a reverse Uno. And the reverse Uno lies in the first two. I am so sorry. The the first two paragraphs of the original complaint that ended up in the New York Times and subsequent other news publications. Now we're going to go through that, and then it's going to loop us around through some questions about metadata, source of the 30-point agreement or even 17-point agreement, and then we'll wrap around to a timeline, and then that'll get us back to hopefully looped us back around to the second paragraph, and we'll go line by line, word per word through her complaint, just as you would, as if you would be doing, I don't know, like union contract ratifications, right? In union contract ratifications, you go through line by line, word for word, because every word has a different meaning or different context. And if you change one, you change the entire context of a sentence and can change the entire context of a contract. So that's what we're kind of doing with the with her first complaint, is just taking it word by word, line by line, and we're comparing it to what we know now. Okay, so in Lively's complaint, and I'll read like the first two paragraphs of it because we already went through most of paragraph 1. So it says, on January 4, 2024, prior to resuming filming of It Ends With Us, following the guild strikes, an all-hands meeting was convened in New York to address the hostile work environment, right? We went through all of the attendees at the time, or we went through the attendees yesterday, right? And we got up to Todd Black, a producer on the film, and Miss Lively, who played the role of Lily Bloom in the film. Miss Lively also had the agreed upon right to have a represent present. Now remember, that was in her original 17-point agreement. She chose her husband. Well, who was her husband? Our favorite guy, Ryan Reynolds. Given that the meeting was about repeated SH and other disturbing behavior by Mr. Baldoni and Mr. Heath. So Mr. Heath, Jamey Heath, is lumped all into this, right? So it says, as discussed in detail below, and we're starting paragraph 2. So Miss Lively was forced to address concerns about Mr. Baldoni and Mr. Heath's misconduct with them directly, and began doing so months before filming began. And we'll loop around to that in a little bit. The concerns she raised were not only for herself, but for the other female cast and crew and some who had also spoken up. The January 4 meeting occurred only after Wayfair had rebuffed Miss Lively's efforts repeatedly. Okay, now we're getting down to paragraph 3. We'll address paragraph 2 with the timeline. During the January 4 meeting, the parties discussed in detail the inappropriate conduct that Miss Lively, her employees, and other cast and crew experienced at the hands of Mr. Baldoni and Mr. Heath. After the list below was reviewed and discussed in its entirety, all parties present agreed that the outlined conduct would cease. Now, this includes the producer, Todd Black, and Angie from Sony. Okay. And we're so focused on Jamey Heath at this point in the reverse Uno. So we're actually looking at a 30-point agreement in the court filing, right? And the second point of it states no more mention of Mr. Baldoni's or Mr. Heath's previous pornography addiction or BL's lack of pornography consumption to BL or to other crew members. Okay, that is in the complaint. Now, what the problem is also, it's also in the table of contact. Oh my God, I can't talk. Contents, right? Talks about Mr. Heath's discussed their personal actual experience and previous corn addiction. She's applying that previous corn addiction to both Justin Baldoni and Jamey Heath. Now we know Justin Baldoni has been pretty open about his past experiences in his various books, podcasts, TED Talks, right? But publicly, before, there has been no mention of Jamey Heath in any misconduct, right? At least not that I have found. So let me X out of this one. So the January 4 meeting, right? According to the timeline, it states she began by reading from notes on her phone. Now, let's look at phone. Okay, it's her phone that she's reading notes from. So exactly what is she reading? She's referring to, or there's an inference that she's discussing this 30-point agreement with them, right? So it says she began by reading from notes on her phone, outlining a series of alleged infractions from phase 1. Reynolds then berated Baldoni, demanding Baldoni apologize to Lively for actions grossly mischaracterized. Baldoni resisted apologizing for things he had not done, which further enraged Reynolds. Everyone, including the new producer Lively had requested to join the production, and the Sony representative, left the meeting in shock. Okay, the infamous meeting, HR meeting, or emotionally, verbally abusive meeting, in my opinion, allegedly. Now, how does this apply to Mr. Heath? In Mr. Heath's deposition, he states this quote, or per his deposition, she says, I talked about my genitals. I still haven't heard anybody ask me. She said I had a corn addiction in her complaint. No one has asked me where that came from as it pertains to me, but we talked about it. And I think this last sentence, but we talked about it, means that the lawyers in this current deposition that he's going through have talked about it, right? And this is, they're discussing, what next steps to take and whatnot. So Blake Lively didn't report any dates about said conversation, about said pornography addiction with Jamey Heath. But per her CRD or her lawsuit, she refers to an incident that happened where her driver was a witness too. And that would be Kevin Alexander, I believe, her driver, which was in her initial disclosures, which I believe he was up for a deposition in one of the draft witness deposition lists that I saw. His name was on it, right? So I'm hoping that they interview that person to figure out if there was a conversation on Jamie's part to reflect what Blake Lively has said in her complaint. Now, because the 30-point agreement was in her complaint and clearly said pornography, it was published in the New York Times, which was picked up by NPR. And you have an article dated December 22nd, 2024 at 8:51 p.m. Eastern Time talking about it in her complaint and now in news articles. Let me tell you. Let me see if I pulled up the right part. Okay. So, at the January 4 meeting attended by Lively Baldoni, studio CEO and producer Jamey Heath, and others, the complaint alleged they discussed inappropriate conduct experienced by Lively and other cast and crew. All parties agreed to a list of conduct that would cease, which allowed for the movie's production to resume. Lawyers for Lively said in the filing. The article continues. The list of agreed upon demands, including the complaint, says no more showing lewd videos of women, including the producer's wife, to Lively and or her employees. No more mention of Baldoni's or Heath's previous pornography addiction to Lively or to other crew members. And then it continues. No more descriptions of their own genitalia to Lively. That is in NPR, which was also the same article that was in the New York Times. Jamey Heath is now stating in his deposition that that is not true. And according to the timeline, it says this. Important note, though Lively's CRD complaint misleadingly suggests that the parties agreed to a list of 30 items during this meeting, many of the items listed in her complaint were entirely new, baseless, and never presented or discussed. The only document ever shared with the parties was the 17-point return to production demands, which had been introduced on November 9, 2023. Redacted and lawsuit. I am reading this from document 50 TAC 1, filed 13125 off of the lawsuitinfo.com. So why is this important? Well, where did we see questions about the validity of this document? Right? There was questions about 30 point, 17 point metadata, right? So let's take a look at this pretty spicy email, and then we'll jump over to some interesting little court battle that might have been related to this. And I'll tell you my little tin hat theory as we go along, okay? So we have an email between the two law firms, right? And they are discussing Exhibit 6, BL 22322 TAC 24 at P22324 at 1:03 a.m. And it says this: attaches a document titled IEWU BL Protections Page. As discussed, this attachment was not produced. Please produce the document and include the required metadata. We have discussed this issue on multiple conferrals with other attorneys from your firm. Plaintiff produced full families of all documents. So, to the extent there is a missing child, it is because the underlying document was not saved to plaintiff's iCloud account and was therefore not available for collection. Well, what else wasn't available for collection off of someone's phone? What about Jamey Heath's other birthing videos that he saved on other devices? What if this document was never on Blake Lively's phone? What if it was on Ryan Reynolds' phone? How does Wayfair know that was her exact phone that she was reading from? Right? Because if they didn't pull it off of anything and they don't have metadata for it and she's reading off of Ryan Reynolds' phone, there wouldn't be anything to pull off of that phone as far as metadata on her phone. But there would be a whole bunch of metadata on Ryan Reynolds' phone that maybe we don't want to see. Let me just check in with the chat real fast. Sorry, I have my alarm on at the same time, so if you hear it, I apologize. This is so maddening. The audacity of that sick, not a billionaire Ryan. This is just a tin hat theory. We don't know, but this is just my tin hat theory. Again, we're going through line by line, word for word, like we're, ratifying a contract. But isn't it crazy? I mean, that is the only tin hat theory explanation that I have for where is this metadata. Okay. And then it says we have Justin's text to Ryan Wilson makes me cry. Yeah, that is just heart-wrenching. And we'll get more into the ambush in a few days when we get down to the meeting. But it's pretty interesting. If this is true, then that would bring Ryan Reynolds back into the fold as an agent, because this template or this 30-point agreement looks like it was in the same format or could have been emailed in the same format to the lawyer's office. I believe it's Dern. And side note, Dern is infamous for their business deals. Now we can look back at the text messages of when they found Ted Black and where to send all the contracts and where the deal is. And I think it funnels right back to the same firm that held the 17-point agreement. In my tin hat, allegedly, in my opinion, theory. Okay. So we have that allegation in court documents, right? So if Jamey Heath can prove that there was no mention to anybody about a corn addiction, but yet it was published, Blake Lively would have to prove that statement was true, I believe. And Jamey Heath would have to prove that it was false. But if Blake Lively can't come up with any proof that it's true and it was in a news article, wouldn't that be the same subject for what Johnny Depp and Amber Heard went through? Specifically, what Johnny Depp went through when he lost his defamation part because his lawyer said that Amber Heard went back and roughed up the place and poured wine all over and called the cops again. And the lawyer was guilty because he was acting as an agent for Johnny Depp. But mind you, Johnny Depp escaped defamation, in my opinion, to the studio when he went to complain to Amber Heard's studio and said, hey, there's all this drama, blah, 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 blah. It's not good for your movie. It's not a good look. It's not good PR. I thought that was straight defamation right there. But if it was true, then it wasn't defamation according to the jury. Okay. Next point. I know we're going like back and forth and this is kind of crazy. Okay. Let's continue reading. This is the email. I understand this issue was discussed generally, and this is Wayfair side. I am raising it again, but this time only for 2 specific documents. And side note, remember that we're now dealing with currently the authentication of documents that Blake Lively automatically wants us to authenticate. Is this part of the batches of things that she just wants to say, oh, it's all whatever? I'll have to look at that a little bit more deeper, but maybe this is where everything is originating from in my tin hat theory. Okay. Your statement that the document is missing because the underlying document was not saved to Clayton's iCloud account. Again, what if it was saved to Ryan Reynolds' iCloud account, right? Remember, they're being careful for words. And I skipped a big old part. Miss Lively contends that the protections document is highly relevant to this litigation. Therefore, all versions of this document must be produced. Exhibit 6 to Mr. Stone's deposition is one such document. Well, who the heck is Stone? Because I forgot. Stone, Justin Greystone, is Miss Lively's manager and partner, and he's also listed in her disclosures, along with Kevin Alexander, Blake's driver. But apparently this guy knows parties' alleged conduct, the actual discriminating, harassing, and other inappropriate, unwelcome actions, blah, 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 right? Apparently he has a version of the protections, something, metadata, whatever. Maybe Ryan Reynolds emailed it to her business manager, who then emailed it to another lawyer. I don't know. I don't know what the chain of custody is. Okay. But we are forgetting that there was also a tiff between the deposition of Gray Stone and Lively wanting to go first. Right? Do you remember that? Here's the court order. Whereas the Wayfair parties and Mr. Gray Stone have identified October 6, 2025 as the most convenient date that accommodates the competing considerations set forth above. Whereas counsel for Blake Lively, for defendant Shed Wallace and Street Relations, and for third-party defendant Jones Works LLC stipulate to this deposition taking place on October 6th. This is where they split it, basically, right? Blake Lively got to go first and got to have her 3.5 hours or 4 hours of deposition time. Why? Did they need the information because there's all of these questions? And I'll go back to the email. So listen to this. Your statement that the document is missing because the underlying document was not saved to plaintiff's iCloud account should not end the inquiry. By default, Apple's Pages word processing program automatically saves documents as you work on them. Therefore, the document was either saved locally or on an iCloud at some point in time. Again, could it be Ryan Reynolds? Allegedly, in my opinion. Your um your statement that the document was not stored on iCloud is not specific enough. Was it ever saved to plaintiff's iCloud account? Again, what phone was she reading from? Was she reading from her phone, a burner phone, or Ryan Reynolds' phone? Who knows? Maybe a BlackBerry? I don't know. If it was saved to Clayton's iCloud account, then advise when it was deleted. Okay, are we talking about spoliation and deleting evidence now? Again? In addition, advise if the document was ever locally or saved locally on one of plaintiff's devices, i.e., phone, iPad, computer, or laptop. Again, is this a situation that we could apply with Jamey Heath? And okay, we had this term that was snuck in these court documents, and you did a reverse Uno, and all of a sudden everything is available to us, even though we didn't show you. So if Jamey Heath has to search his computer and other devices, Blake Lively should have to search Ryan Reynolds' devices. If anything of a 18, 17, 30-point agreement is in there. What do you guys think? And if she deleted it, how is that going to look? Right? I continue. Plaintiff has claimed work product protection as early as May 19, 2023, as on her privilege log. Okay, well, what the heck happened in around May 19th? We'll go back through the timeline of relevant events and look at meetings and little tiffs and things like that. I'm going to exclude the dragons, and I'm going to exclude the ambush on Wait, because I feel that has like a lot of hearsay, and I wanted to go to the actual, like, hey, there's other witnesses to this event, and then we'll address the hearsay part a little bit later. Okay, so plaintiff has claimed work product protection as early as May 19, 2023, as on her privilege log, reflecting that as of that date, she anticipated litigation. Therefore, please explain why all documents were not retained and preserved that were dated or created on May 19, 2023 or thereafter. And then this goes on. They also talk about contractual documents that are heavily redacted. And they're just talking about, they have confidential provisions. Okay, number 3, specifically the 30-point list. The 30-point list that appears to be cut and paste into paragraph 20 of Miss Lively's complaint, and also the first 3 paragraphs of the complaint. And I just lost my spot. Okay. Was not produced. Please do so and include the required metadata. That document was produced at BL, and then it gives one bait stamp, and then BL 38462. And here's the issue. We have several issues with your response. First, the metadata for the 2 pages you list above reflects a creation date of July 23, 2025. Now, when I saw this, I thought it was a typo. I thought it could have been July 23, 2024, maybe July 23, 2023. But if this is BO with, I don't know, a bait stamp or creation of 2025, does that mean that she had to go and recreate the document from her original complaint, or possibly, allegedly, in my opinion, Ryan Reynolds' phone, to get it in, to give the metadata to cover up all of this conspiratorial, crazy tin hat theory jumbled mess? Because now I just feel like I'm going crazy. And it's like we're going in circles. This whole thing is just so conspiratorial. Okay. And then the 30-point list in the second amended complaint first appears in the CRD complaint on December 20, 2024, and the complaint alleges that this list existed as of January 4, 2024. Obviously, the July 23, 2025 created documents cannot be what Miss Lively alleged read on January 4, 2025, as it was not created until July 2023. Who created this document? Second, the two documents produced appear to be screenshots of yet another documents that was not produced. Screenshots, like maybe from somebody else's iPages, iCloud, notes. Maybe they, I don't know, printed it from a phone. And these are just crazy tin hat allegedly theories, in my opinion. Okay. Note the envelope legend on the bottom of page 38461. Where is the original document with the metadata as required by the ESI protocol? Was it destroyed or deleted? If so, when did that occur? What if it was never destroyed or deleted? It's just somewhere else on somebody else's phone. And if that's true, and if it was on Ryan Reynolds' phone, and he made the allegation of Jamey Heath and his alleged corn addiction, would that be defamation? Because it's Ryan Reynolds and he's not directly involved and was not directly present for said corn addiction comments, right? And what if he wasn't even present with Kevin Alexander in the car, Ryan Reynolds? So he would never be witness to hearing that corn addiction, right? I mean, unless somehow, and I kind of think that this might happen, that maybe Justin Baldoni was being illegally recorded in the penthouse because it's a one-party state. So only one party can listen on. And then maybe they just rewound the tape and took some notes and just tin hat theory. Okay. Finally, if this document was destroyed, please advise when it was destroyed and explain why it was not preserved, given Lively's claim that she anticipated litigation as early as May 19, 2023. Also, another thing, this close set, Ryan Reynolds probably wasn't a part of it unless he was essential personnel or designated or something. So did he witness all this? And does Judge Lyman have a point? Did Blake Lively go home and say, hey, hubby, this is what happened. I was all naked and in stirrups and blah, blah, blah. And then Ryan Reynolds got jealous. I don't know. And then again, we get down to about that. Number 5, to the extent that there are multiple versions and or red lines of the alleged protections or requirements documents, which we apparently stored on which were apparently stored on Miss Lively's computer or other electronic devices, they must be produced. We note that no such document appears on Miss Lively's privilege log. Plaintiff has produced all non-privileged versions of the protections for return to production. Certain versions have been withheld on privilege grounds and are reflected in plaintiff's privilege log, captured by certain entries with descriptions regarding on-set conduct. Well, we know that she did go to, whose office was it? Dern, Offer Dern, right? But how did those emails or messages get there and through what phone? Again, your comment raises issues regarding the adequacy of Clayton's privilege log. The description of many of the items listed on the log read email providing or reflecting legal advice of Sloan, Offer, Weber, and Dern, the authors of the 17-point agreement. And I believe they did a deal allegedly, possibly, with Todd Black as far as the 17-point agreement. Allegedly, in my opinion. You now claim some of those include versions of the protections or requirements document. We note that BL 38461 Tax 62 is Blake Lively's updated Lindsay Slassberg list of protections. Is Miss Slassberg's list, which Blake Lively revised on the privilege log. Which entry is it? And then it continues. This reveals that your privilege log is insufficient, as it does not allow us to evaluate your claim of privilege. For example, the documents with the titles reflected in numbers 1 and 4 above are not privileged, and if a document bearing the title was withheld on the grounds of privilege, we are entitled to challenge it. According, Ms. Lively must 1. Identify each of the entries on the log that contain, summarize, or attach any versions of the protections or requirements document and identify it as such. 2. Provide the author of each such document or revision. Author might be Ryan Reynolds, or it could have been her agent, maybe. 3. If an attachment, provide the name of the document, i.e., IEWU BL protections pages, so that we may properly evaluate your claims of privilege and provide descriptions other than simply concerning on-set conduct or post-production conduct. These issues have caused us to examine your privilege log more closely. Who is Susan Kent? I believe Susan Kent was the CEO of the PR company that dealt with content creators. I might be getting these names mixed up, or the roles mixed up. Cami Aspar and Phil Singer, I believe they are in music and they're very well known and acclaimed. One is a sound mixer and one is a sound engineer, I believe. I'll have to double check that in my notes somewhere. I might be wrong, but I'll double check. In addition, you have claimed a common interest privilege with Colleen Hoover in her privilege log with attorneys. Did she take Colleen Hoover to Offer Dern and whatever? because Colleen Hoover in her deposition said she never planned on suing anybody, right? Ms. Hoover recently testified that she never contemplated filing an action against the Wayfair parties. Accordingly, this document must be produced. We look forward to your prompt response. So, does Jamey Heath have a reverse Uno based on what Johnny Depp went through? What are your thoughts? I might end this a little bit early just because I have the live a little bit later, but the kiddos are about to wake up, and it is a Monday for school with kid conferences. So let me just go through the chat. If you guys have any input, let me know. The Wrathful Proser said that's true. See Ryan, there's still hope. Yeah, I think we just keep pulling Ryan Reynolds back, and now it's getting a little bit more dicey. Where is Ryan Reynolds' metadata is what I want now. Let's take his phone and what's on there. Joe says, I hope Jamey had the sense to record what happened in the penthouse. I don't know if they thought about that, honestly, but what if Blake Lively and Ryan Reynolds did? But that's a very creepy thought as well. I mean, that's just stalking, but I don't know. Do you think Ryan Reynolds has it in him to stalk people and to record people without their knowledge? He did say they work like the mafia. Steve Sarowitz's deposition was interesting, saying that, it was authorized from the other side. And I've read that in his deposition for you guys. And also another question, how dangerous is this getting? You know what I mean? You have threats of physical harm. You have threats of supposedly, allegedly, in my opinion, ending someone's life because you don't want them to go to a premiere. Someone's house catches on fire and they're digging and digging and digging, and somehow the victim knows that there was an authorization from somewhere. And this whole thing is connected. And now we're going to go on to another conspiracy theory of, something dark happening in between them. It's just this huge rabbit hole that I didn't even think that we're going to go down. And I wasn't intending to go down this tangent either. But what are your thoughts so far? And we've only made it through like the first, 3 paragraphs of the complaint originally. So it doesn't look good because like what TMZ said, we could pretty much debunk a lot of her claims. And we did just within 2 paragraphs. And if we can do this and debunk it, what was New York Times not debunking? Did they not? If they took another day or two to look into all of this, do you think they really would have published what they have? And does that put them in a tighter spot? And now that we have all of this more information coming out, is this a reason why New York Times raced to have this case closed? Or to have Blake Lively pause it and put the brakes on it so we don't have any more stuff coming out that looks really eek? Do you think I'm crazy for having this kind of theory? I mean, now I feel just insane, but this whole lawsuit and the events leading up to it doesn't seem normal. Girly 1209 says if they recorded the penthouse incident, They failed to frame him into confessing to things he never did. And maybe that was what Rainn Wilson said in his text message. Maybe it was a setup. Maybe they were. That is a good point. And we'll take a a closer look at that. So tomorrow I'll pick up and we'll go through the timeline, starting with May 19th. Per her, she was, preparing for litigation. We'll take a look at that. And then we'll keep on going through the complaint line by line, word per word. We'll look at the 30-point list that either is deleted or not on her phone devices, but may be in Ryan Reynolds' possession or even her manager's possession. And yeah. So let me know what else you would like to hear. Let me know what your theories are. Like, subscribe, share. And I'll see you tomorrow morning. Is this time a better time for everybody? We're not up as early as we were before, so like between 6 and 6:30, a good time for everybody. Let me know in the chat. Thanks for joining me. I hope you guys have a beautiful day, evening, night, and we'll see you tomorrow. Thanks, house guests. Have a great day.